Dictation will be started in few seconds. If you are new here, then subscribe the channel for more new dictation. Start. The learned senior counsel appearing for one of the appellants submitted that the case is squarely covered by the ratio of judgment of this court in Himani Malhotra versus High Court of Delhi. Stop. That case pertained to recruitment to the higher judicial service in Delhi. Stop. The mode of selection was written test and Viva voice. 250 marks were assigned for written test and 750 marks prescribed for Viva voice test. Stop. When the advertisement was given, there was no stipulation prescribing minimum marks, cut-off marks at Viva voice test after the written test was held. Stop. The persons who qualified the written test were called for interview. Stop. Interview was, however, postponed by the interview committee and it felt that it was desirable to prescribe minimum marks for the Viva voice test as well. Stop. The matter was placed before the full court and full court resolved to fix minimum qualifying marks in Viva voice which were 55% for general category, 50% for SC/ST candidates. Stop. After this change was effected in the criteria, thereby prescribing fixation of minimum qualifying marks, the interviews were held. Stop. The petitioners in that case were not selected as they secured less than 55% marks. Stop. Those two petitioners filed the writ petition submitting that prescribing minimum cut-off marks in the Viva voice test, after the selection process had started, when there was no such stipulation at the time of initiation of recruitment process, was unwarranted and impermissible. Para. The court, taking notice of its earlier judgment in Leela Dhar versus State of Rajasthan, held that when the previous procedure prescribing minimum marks was not permissible at all after the written test was conducted, the ratio of the case is summed up in paragraph 15 of the judgment, as there is no manner of doubt that the authority making rules regulating the selection can prescribe by rules the minimum marks both for written examination and viva voice, but if minimum marks are not prescribed for viva voice before the commencement of selection process, the authority concerned, cannot either during the selection process or after the selection process add an additional requirement qualification that the candidate should also secure minimum marks in the interview. Stop. Therefore, this court is of the opinion that prescription of minimum marks by the respondent at viva voice test was illegal. Stop. This very argument based on the aforesaid judgment was taken in the LPAs before the High Court as well. Stop. However, the High Court took the view that the aforesaid judgment was not applicable in the instant case as the factual scenario was altogether different in this particular case. Thanks for watching.